How and when do Miranda rights come into play in an encounter with the police? Attorney John Haughton explains, "You have the right to be advised of certain rights, otherwise known as Miranda rights, named after the case which established the rights of the citizen to be informed of these rights. Miranda v. Arizona, 1969, U.S. LEXIS 1137, 396, U.S. 868, 90S CT 140, 24L ED 2D 122. The Miranda warning is generally as follows. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford an attorney, one will be provided for you. Do you understand the rights that I have just read to you? With these rights in mind, do you wish to speak to me?" Miranda rights kick in once a person is no longer free to leave the encounter. A police officer can come up to you and just ask you questions. If he is not detaining you, then he doesn't have to give you those warnings. However, there is enough uncertainty in criminal law that you shouldn't depend on or wait for the officer to give you Miranda warnings. You have the right to remain silent, even before he gives you the warning, and you should assert that right. Provide the officer with your identification, and then you can assert your right not to say anything else and ask for an attorney. At Haughton Law Group, PC, our decades of legal practice means that we can analyze your case quickly and accurately. We have acquired extensive knowledge in our chosen practice areas and also knowledge of the customs of the courts, judges, and attorneys throughout North Texas. We work hard to resolve cases fairly